Distinguished guests, especially the Honourable Michael Kirby, good evening. My name is Stephen Bottomley. I'm Dean of the ANU College of Law, and on behalf of the College and our Centre for International and Public Law, it's a great pleasure to welcome you all here to this, the 8th annual Kirby Lecture on International Law, to be delivered this evening by Professor Gerry Simpson, a long-time friend of this law school. To begin, I acknowledge and celebrate the first Australians on whose traditional lands we meet this evening and whose cultures are among the oldest continuing cultures in human history. Thank you all for braving this invigorating Canberra winter evening to attend tonight's lecture. The annual Kirby Lecture on International Law is one of the highlights of our college's annual calendar of events. They sort of all start coming around this time of the year, and we certainly look forward to them all, but particularly this one. This lecture series was established back in 2008 to recognise and to celebrate Michael Kirby's long-standing passion for and his service to the field of international law. The lecture series also recognises that the study and the teaching of international law is also one of the great passions and strengths of this law school. Those of you who have attended either of the past two lectures given last year by Professor Andrew Burns, who I'm pleased to welcome back tonight, and the year before by Professor Gillian Triggs, you may recall that we were welcomed by Michael Kirby through the medium of a video up on the big screen. I'm very pleased that this year Michael can join us in person. It's great to have you here. And instead of an introductory video, Michael will be making some remarks at the end of Gerry's lecture this evening. So thank you again for being here tonight. I only want to make my welcome brief. I'll now hand over to my colleague, Professor Kim Rubenstein, Director of our Centre for International and Public Law, to introduce our speaker. Thank you.
Thank you, Stephen, and welcome everyone to this year's Kirby Lecture in International Law. Just a few extra comments about this lecture, because many of you will know that we have traditionally held the lecture in conjunction with our Australian New Zealand Society of International Law Conference, an annual conference that is held 2 years in Canberra and 1 year in New Zealand. So this year is the year that ANZL was held in New Zealand, and the principle was always that we would hold the Kirby Lecture as a standalone lecture, of course, when ANZL was in New Zealand. And in thinking about the timing for this particular lecture and when it would be best located through our very busy schedule, as Stephen alerted to, we determined that it would be most appropriate to link this year's Kirby Lecture with tomorrow's very important symposium marking the contributions of Deborah Cass. And I'd like to acknowledge the Cass family who are sitting in the front row next to Michael Kirby. And Michael, without any disrespect to the attention of this lecture on his contribution, we felt it was very timely to link the Kirby Lecture with tomorrow's conference, which will be marking the contributions of Deborah's work not only in public law but in international law. So in many ways, the principles of Michael's scholarship will be played out tomorrow further with our attention to the significant contributions of Deborah Cass to the scholarship in that area. And similarly, in thinking of who would be an appropriate person to present tonight's Kirby Lecture, our minds went directly to Professor Gerry Simpson, who I'm delighted to welcome today and who will also be participating, of course, in honouring his wife's work. Gerry Simpson holds the Kenneth Bailey Chair of Law at Melbourne Law School. In fact, probably many of you here don't need much of an introduction to Gerry, but for the record, and we are being recorded, so for people who are not aware of Gerry Simpson's contributions before now will find out, where he has also been Director of the Asia Pacific Centre for Military Law and has been over time, a visiting Professor of Public and International Law at the London School of Economics, where he will be returning later this year. So in some ways, this is also an opportunity for the ANU College of Law to recognise Gerry's contributions here in Australia, and of course his particular connection here to ANU because he was a senior lecturer here from 1996 to 1998 and has a continued association in teaching in our master's program. In addition to his immense scholarly output, Gerry has also had a role to play in the practical application of international law, which also fits with the tribute that we're making to Michael Kirby tonight. Gerry was a member of the Australian delegation at the Rome Conference to establish an international criminal court in 1998 and worked as a legal advisor to the Department of Foreign Affairs and Trade between 1995 and 1998, and he has also worked in the NGO field providing legal advice, and has appeared, as many of us know, in the media, both here and in the UK, commenting on international law in practice. So without any further ado, I really have great pleasure in welcoming my friend and colleague, Gerry Simpson, to deliver his Kirby lecture tonight at the title that we can see here above us. Please welcome Professor Gerry Simpson.
Well, thank you. It's lovely to see so many friends out here in the audience tonight. I'd like to begin by thanking CIPL, the ANU College of Law, and the ANU itself for hosting this lecture. Special thanks go to my friend Kim Rubenstein for organising the lecture, inviting me to present this evening, and for her lovely introduction. Thanks also to Nicole Harmon for facilitating the event and the travel to the event. Well, it's a pleasure to be back at the ANU, where I, as Kim said, spent several happy years, and in Canberra, where one of my daughters, Rosa Cass Simpson, who I promised not to mention by name tonight, was born at the Calvary Hospital in 1998. I would like to thank Justice Kirby for giving his name to this lecture and for being present this evening. Like Stephen, I came to a Kirby lecture once where Michael appeared on an enormous screen behind the podium, introducing but at the same time dwarfing the lecturer. I'm referring briefly to Orwell this evening, and there was something vaguely, though benignly, Big Brother-ish about Justice Kirby's appearance that night. Finally, though, I want to mention the three deans I've worked with at the ANU Law School. Stephen Bottomley for his good-humoured support during my various visits to ANU Law School in recent years. Tom Campbell, who I'm delighted to see right here in the third row, for hiring me as a lecturer and for intellectual guidance and friendship. And to Michael Coper, whose stylish, witty deaning would always light up evenings like this. Despite an impassioned speech by its foreign minister, there was a failure to win Security Council support today for a resolution condemning the downing of the airliner. Diplomats said they would have to settle for a less harshly worded statement. This passage is taken from the front page of the New York Times, July 14th, 1988. The destruction of the airliner was described by the sponsoring state as a pure act of terrorism, a ruthless crime. But the state allegedly responsible for the act called it a tragic but understandable mistake. The incident was complicated by the fact that it had taken place in the midst of a war with its own very profound geopolitical consequences. In early July 1988, an Iranian Airbus, Flight 655, carrying 290 passengers, was shot out of the sky by two missiles fired from a US warship. I'm going to move this down here so I can put the pages I've already come to there. Okay. The captain was eventually commended for his action with a Legion of Merit. Soon-to-be President George Bush Sr. said on the election trail, "I will never apologize for the United States. I don't care what the facts are. I'm not an apologize for America kind of guy." The International Civil Aviation Council, meanwhile, at its meeting in Montreal in March 1989, and I quote, deeply deplored the tragic incident which occurred as a consequence of events and errors which resulted in the accidental destruction of an Iran airliner. Of course, this all sounds very like the recent events surrounding the shooting down of MH17. One very important distinction, though, between this incident and last month's Security Council meeting, and a distinction that lies at the heart of this presentation, is that the Iranians wanted a Security Council resolution condemning the action. The Australian government certainly wanted that this year, but it wanted something else as well. It asked the Council to establish a war crimes tribunal to try those responsible for the deaths of the passengers. The Security Council draft resolution was very circumspect in its language, though, with the Council, and I quote, convinced that in the particular circumstances of this incident, the establishment of an international criminal tribunal is warranted, and deciding further to establish an international tribunal for the sole purpose of prosecuting those responsible. I hope to show tonight that this particularism is a standard feature of war crimes law, and that it rubs uneasily against the apparent universalism of international criminal justice and the requirements of generality in the rule associated with the rule of law itself. In less circumspect language, the Foreign Minister, Julie Bishop, said that the failure to establish a court would be an insult to the memory of the dead and an affront to their survivors. Nothing less than war crimes prosecution would satisfy the Australian government and the Australian people. There must be no impunity. The Russian veto, as she put it, only compounds the atrocity. The Prime Minister, too, called the Russian veto outrageous. Samantha Power, the US permanent representative to the UN and the author of a well-known book on war crimes and genocide, described the attack as heinous and the use of the veto as tragic. It's doubtful, I think, that too many people listening to the ABC broadcast of Miss Bishop's speech would have found much to disagree with. After all, who could disagree with a call for justice? In Sloan Wilson's novel, The Man in the Grey Flannel Coat, later a film with Gregory Peck, a Judge Bernstein receives a phone call from Schultz, a man demanding justice. Bernstein reflects on the call, and I quote, "How violent Schultz had sounded over the phone. 'I want justice,' he had said. 'I wonder how many wars have been fought with that as its slogan. Justice is a thing that is better to give than to receive, but I am sick of giving it.'" Meanwhile, another magistrate in J.M. Coetzee's Waiting for the Barbarians has spent his life administering the law in a small fort at the end of an unnamed empire. When Colonel Joel from the State Security Service arrives to dispense justice in the form of lethal torture to two barbarian fishermen accused of terrorism, the magistrate too becomes sick of justice. He says, "Justice. Once the word is uttered, where will it all end?" Later, Joel discovers that the magistrate has a collection of barbarian scrolls. He takes this to be evidence of treason, and the magistrate himself is then tortured. At one point, the magistrate is asked to read one of the scrolls. He says, "See, there is only one character. It is the barbarian character war, but it has other senses too. It can stand for vengeance. And if you turn it upside down like this, it can be made to stand for justice. There's no knowing which sense is intended." And John Brigg, the coroner in Ronan Bennett's Havoc in its third year, too grows weary of the endless calls for justice and correction. And like Coetzee's magistrate, he ends up choosing the anarchism of life on the road over the inflexible administration of law. The latter two novels are haunting studies about lives doing justice and the refusal in the end to continue doing justice. There comes a point, it seems, when one can no longer do public justice. The world won't allow it, or justice has become revenge, or the society has succumbed to what Judith Butler has called penitentiary logic. These three works of literature describe a world weary of the endless search for perpetual justice. And interestingly enough, international law begins in this mode in 1648, when the great European religious wars of the 16th and 17th century come to an end at Munster and Osnabrück. This is from the Peace of Westphalia, another quote. "That there shall be on the one side and the other a perpetual amnesty or pardon of all that has been committed since the beginning of these troubles, and that all that has passed on the one side and the other during the war shall be buried in eternal oblivion. This is the law of forgetting, if you like. It's these amnesties and pardons, essential to the great diplomatic achievement of Westphalia, that are now so often deplored by Amnesty International and others when such mechanisms are used to shield human rights violators. So tonight I want to offer a critical stock-taking of a century of doing or attempting to do international criminal justice. And the central question, I think, can be posed in the following terms. Can international justice be done in this world? And I mean this in non-metaphysical terms. In other words, I'm not interested in whether it can be done elsewhere, though this is one of the standard lines of argument advanced by the Nazi war criminals. Adolf Eichmann, for example, whose name might come up a bit tonight, demanded that he be judged before God and not before the district court of Jerusalem. But let's bracket theological inquiry and ask whether the world is constituted in a way that permits us to do justice in a manner that does not simply reproduce or reenact injustice in a different and disguised register. To put this simply, is the international diplomatic system ready for international criminal justice? Or have we got ahead of ourselves a bit? To put it even more simply, was the Nuremberg trial, for example, the trial of the century, the moment when the Allies, in Robert Jackson's stirring phrase, stayed the hand of vengeance? Or was it, in the words of another judge, Jackson's U.S. Supreme Court colleague, Harlan Fiske Stone, Justice Harlan Fiske Stone, a high-grade lynching party? In the case of Bennett's and Cotzia's magistrates and coroners, the societies in which justice is being pronounced just seem too fragile, violent, radically unequal, and full of crazy superstitions to accommodate a form of law that does not inevitably lapse into correction, discretionary, spasmodic, and then sadistic punishment, and the eventual peevish resistance of its practitioners. This was the insight that the diplomats brought to Saxony in 1648. In a world where claims to justice or religious truth are pursued through savage and implacable violence, it's best that international diplomacy sets aside the claims of justice altogether and simply gets on with the not simple task of making sure sovereigns at least get on with each other. Antonio Cassese defended international criminal law by saying that some of it was better than nothing at all. And this is an absolutely standard defense of the imperfections of international criminal justice. Is it possible that some of it is worse than none of it? Indeed, that a lot of it might be worse than none of it. And that in order to think about this, one must be attentive to the intimacies between law's violence and the violence that law is intended to repress, a familiar enough idea. And alert, too, to the violence that law, certainly international criminal law, might be implicated in the perpetuation of. At the very least, and when faced with the overheated language of the political class, these are possibilities, I think, worth considering. But it's rather important that I say something else. The trial of Hussein Habri, which began last week, or the Adolf Eichmann trial, represent moments of tremendous catharsis and perhaps healing for the victims of mass atrocity. So any critique of international criminal justice has to reckon with the enormous and entirely understandable emotional appeal of such trials. Well, let me tease all of this out a bit by returning to Julie Bishop. There are some things to notice about the MH17 diplomatic tussle, and these markers will appear and reappear as we move through the century. First, something has happened to the way we think about the world, and this shift in sensibility can be felt, I think, in the differing responses to the 1988 incident and the present crisis. It now seems natural to call for war crimes trials in 2015 in a way that would have seemed incongruous or diplomatically maladroit even as recently as 1988. And this reflects an adjustment in our thinking that dates back to the beginning of the 20th century. In essence, we seem to be in a more retributive mood these days, or at least our mood of retribution is more juridical. What might have seemed unnatural in 1915 has become commonplace in 2015. Of course we punish our enemies in trial, haven't we always? And indeed, the language of war crimes law has become a primary idiom through which war is resisted too. In 2015, to argue against the misery of war is to speak like a lawyer. In 1915, resistors spoke like poets. Now, though, serious violations of the laws of war, Article 3 ICTY statute, has displaced in our language the butchered, frantic gestures of the dead, Siegfried Sassoon, the counter-attack. And this leads on to a second aspect of the MH17 and Iranian Airbus disputes. Notice the way in which, in both cases, the injured state casts the offence in the language of crime, or act of war, or atrocity, while the respondent state, as it were, preferred to characterize the event as human error or political misjudgment. This, I think, too, sums up the way in which the move from the 19th to the 20th century can be thought of in terms of a revolution in the meaning of what it means to be defeated in war. What was once political folly became at a certain point criminal act, and war became pest control, to use Carl Schmitt's language. And so the descriptions and redescriptions of the M17 and Iranian Airbus incidents mirror a whole historical transformation in the meaning of war. But this relationship between incidental effect of political action on one hand and crime against humanity on the other lies at the very heart of the international criminal law problem. The question is, do we have the moral and political and legal resources to make this distinction stick? Among the North Atlantic elites, decisions to go to war remain, even today at worst, mistakes to be subjected to administrative action, Chilcot, Hutton, Butler, or electoral reversal, Aznar, Blair. Elsewhere, though, such mistakes quickly become crimes, Gaddafi's war on Benghazi. To put this rhetorically, their mistakes have become crimes, while our mistakes remain mistakes. Third, it's worth attending to the silences and evasions present when there is a call for a war crimes trial. What is not being demanded? In the case of MH17, we might note that there's no call for a permanent tribunal to oversee civil aviation terrorism in general. Or we might notice the lack of enthusiasm for a tribunal to look into alleged killings of Tamils in Sri Lanka, or the destruction of cultural property in Tibet. So the call for an MH17 tribunal feels a little like the Royal Commission into pink bats or wind farms. One encounters such proposals and thinks, why this? Why not that? And I think, again, any institutional history of war crimes trials has to continually reckon with this question. I just realized there are some international guests who are probably wondering what pink bats are out there. That will be explained later. This is what I would call the problem of ad hocery. Ad hocery, or selectivity, is not just an occasional effect in the application of justice. Of course, one can never do justice all the time to all people. But war crimes law at the moment still seems to be built on a deep structure of unequal application, and that can't just be wished away by better law or the hope of moral improvement. International criminal justice is the application of ad hoc law. It always has been, and it will be for at least the next 50 years. We must stop judging it by what it is not, but what it yet might become. And it's not just unequal application. Its norms themselves, even if they were applied all the time against all war criminals, would simply establish a world in which there was a sharp and now familiar division between expendable and non-expendable life, or between precarious and precious life, or between the violence of death by hand and the violence of death by political economy. As the Malaysian representative said in the debate around the Security Council resolution, all those who travel by air will be more at risk if the perpetrators are not held to account. Maybe the world really is divided between people who travel by air and people who travel by boat. Finally, we have the problem of vengeance. I subtitled or titled this lecture, Human Rights with a Vengeance. I take this to mean at least a couple of things. One is that international criminal tribunals are imagined, I think, as a way of giving human rights machinery the potency it has sometimes lacked. To apply human rights with a vengeance is to apply rights with power, credible force, and vigor. I don't think I have come across a single student in the past 10 years who has expressed an interest in working for the UN Human Rights Committee. The UN Human Rights Committee, as many of us know, promotes and encourages human rights observance. If Weber is right, and politics is the long, slow boring of holes, then the Human Rights Committee is boring very deep holes very slowly. And this might feel like bureaucratic madness, or it might feel like institutional heroism. Whatever it is, this sort of human rights work, patient, cajoling, politically sensitive, is nowhere near as glamorous or high profile as working for international criminal courts. I once received a letter from a person working on the prosecution team at a war crimes trial. He wanted me to read a quite lengthy draft essay of his on some aspect of international criminal law doctrine. Because I didn't know him, and because I wasn't interested in reading the essay, and because I hadn't yet read the brothers Karamazov, I very politely declined and wished him well in his work. I received an outraged email back the next day accusing me of being uncollegial and reminding me that he was prosecuting President... Well, I won't say which president he was prosecuting. The point is that for some people, to work in international criminal tribunals is to feel oneself to be at the center of international politics and to be unlike everyone else in that realm, riding on the wings of angels, doing human rights not with a slow boring of holes, but with a vengeance. But vengeance has literal meanings too. Is international criminal law a form of human rights work motivated or inspired by a desire for vengeance? Revenge is never announced as the engine or rationale for war crimes trials. The standard panoply of justifications include remembrance, reconciliation, vindication, and usually wedded together, peace and justice. But as we can see, some of the language of the M17 diplomatic spat sounds quite full-blooded and full too of intimations of revenge. And here I begin my long-awaited stock-taking, international criminal law begins with a moment of vengeful fury. When does history begin? Or the history of a particular field? One possible history of war crimes law begins conveniently almost 100 years ago. We are in the era of the anniversary. I feared everyone would look at the screen instead of me when I put this image up. We're in the era of the anniversary, the Somme, Gallipoli, Vimy Ridge. My history begins on August the 3rd, 1915, almost exactly 100 years ago, with the court-martial of an English nurse, Edith Cavell. Cavell had been found guilty of aiding Allied prisoners in their escape from Belgium during the German occupation of Belgium, the German occupation of Belgium. She was convicted of a breach of German military regulations and an act of treason. That's not Cavell, obviously, that's an actress playing Cavell in the image. This was a strange charge in the context, given that Cavell owed no loyalty to the German state. But it's a charge that resonates through this field of law. I'm going to take this image down now. Despite a flurry of diplomatic protests, in response to which the German ambassador to the US rather unhelpfully said he would shoot 5 English nurses if he had them in custody, Cavell was executed on the morning of October the 14th at the National Rifle Range in Brussels. The Germans, already accused, often falsely, of unspeakable crimes against the Belgian population, were immediately demonized further. Lloyd George went to the 1918 election with one of the most compelling election slogans of the 20th century: hang the Kaiser. The promise was made, and though the Kaiser remained resolutely unhanged after the war, this promise became the foundation of international criminal law. Kaiser Wilhelm died peacefully on June the 3rd, 1941, a month or so before Hitler's invasion of the Soviet Union. And these two events together conjoin 2 origins of the field, at Versailles and later at Nuremberg, where Hitler's march on Moscow is prosecuted as a crime of aggression. Back in 1918, though, at the Imperial War Cabinet meeting at 12 noon on November the 20th, Lloyd George is presenting his proposal to try the Kaiser for the crime of aggression. Lord Curzon, the Lord President of the Council, opens the meeting by remarking that there's no need even to argue for the trial of the Kaiser. He is, after all, the arch criminal. Indeed, as Curzon reports, the French had not yet bothered to consult their own international law jurists about the trial. Why bother? No matter, the Kaiser could be put on trial and declared a universal outlaw. Lloyd George continued the discussion. Well, with regard to international law, well, there's such a lot hanging on that word, well. We're making international law, aren't we? And all we can claim is that international law should be based on justice. There is a sense of justice in the world. There is some resistance to this innovation, though. Billy Hughes, the Australian Prime Minister, is puzzled by the suggestion. As he famously puts it, why not try Alexander the Great or Moses? Hughes' point seems to be that what we call the crime of aggression used to be known as history. You cannot indict a man for making war, Hughes continues. And in a supremely evocative phrase, he equates the whole idea of criminalizing war with what he calls treason against mankind. An absurd and eccentric idea for him, but a phrase that carries enormous weight now as we consider how unself-conscious we have become about deploying the international community against outlaws or about referring to crimes against humanity. Hughes is in the end outvoted, but not before he receives some support from the Minister for Munitions, only there in an advisory capacity. This minister, a minor figure called Winston Churchill, argues that the Allies should be within our rights to kill the Kaiser as an act of vengeance, but that it would be much more dubious to deal with them on the basis of what is called justice and law. Note the hesitant phrasing. At Versailles, then, the law of war crimes begins with some familiar patterns: anxiety about the relationship between revenge and justice, a cavalier attitude to the role of actual lawyers, a belief on the part of the proponents of trial that the justice of the cause renders unnecessary legal process and precedent, and the first sign that when it comes to war crimes and crimes against humanity, the identity of the perpetrators matters as much as the identity of the crime. Treason, of course, depends less on what is done and more on where one stands. And where one stands can be a matter of chance. Or as Lenin once put it, he went into one room and found himself in another. Usually, the history of war crimes trials passes over the interwar years in silence. This was a period in which the efforts of progressives seemed to be directed elsewhere at social and economic change, the League of Nations, and so on. But are the Moscow show trials perhaps the missing link between Versailles and Nuremberg? Historians of international criminal law tend to think of Solferino or the Hague Peace Conference in 1899 as precursors to the trials in post-war Germany. Moscow 1937 is an embarrassing antecedent after all. Judith Shklar defines show trials as the liquidation of political enemies using legal procedure. Stalin knew all about that. But in this, he doesn't seem so far removed from Lloyd George and Lord Curzon. Establishing a tribunal for the specific purpose of liquidating or punishing an enemy. This is what the Imperial War Cabinet was debating in 1918, and it looks a little like what the Security Council was debating 2 weeks ago. Of course, the Moscow show trials were very unlike the Nuremberg war crimes trials in many telling respects. But the idea that people's justice or humanity's justice or a sense of justice can somehow dispose of the need for proper procedure or legal precedent represents a sibling dark side of these trials. A show trial is one in which it's obvious that the guilty are guilty, after all. The trial seems otiose, the mere performance of a justice already delivered elsewhere. Wyszynski, the Soviet prosecutor at Moscow, was also at Nuremberg. During dinner with the judges at Nuremberg, he raises a toast. To the defendants, they will all hang. This was before the trial had begun. But Roosevelt, too, was worried about acquittals, and his concern made its way into the IMT Charter. But maybe these trials are as much about political spectacle as they are about legal propriety. For Hannah Arendt, a show trial is a spectacle with prearranged results. The point of the trial is the trial itself, its ramifications, its warnings, its effluxions of terror. George Orwell understood this. That's John Hurt, of course. Mrs. Parsons lives with her 2 little demonic children at Victory Mansions. Her drains are blocked, as they often are, and she calls Winston Smith down to help her unblock the sink. The 2 children torment Winston, calling him a Eurasian spy, threatening to vaporize him, and shouting Goldstein as he leaves the flat. Mrs. Parsons is apologetic. The children are furious, she explains, because she failed to take them to the hanging. I quote, "Some Eurasian prisoners guilty of war crimes were to be hanged that evening. This happened once a month and was a popular spectacle." It strikes me as important to think about trials in this way, not as depoliticized programs of management, but as slightly wild-eyed theaters of revenge, human rights with a vengeance. As one of the observers of the Moscow show trials eerily put it, these were dramas of subjective innocence and objective guilt. This objective guilt was repeatedly enunciated in the months preceding the major trials at Nuremberg and Tokyo, where the Nazis are described as the world's worst criminals, and where the defendants were chosen with great care on the basis of the political impact it might make. The show trials themselves continued into the 1950s, most famously in Prague, where the purpose was not to determine guilt or innocence, nor even to remove political opponents, but rather to create them. When Rudolf Slansky's name was mentioned, he was the General Secretary of the Communist Party at the time, the Czechs were astonished. What about the evidence, they said to their Soviet advisors? One Soviet legal advisor, soon to be himself purged, said, "We have been sent here to stage trials, not to check whether the charges are true." As for the existence of legal norms at these trials, this didn't matter. The instincts of the proletariat would stand in for what Kirilenko, one of the Moscow prosecutors, called bourgeois sophistry. And this recalls, too, a Nazi law of June 28, 1935, referring to the need to punish criminals and deviants according to the sound perceptions of the people. 10 years later, though, President Roosevelt was worrying about acquittals on technicalities, and Robert Jackson, pressed on the existence of crimes against humanity or aggression, replied by saying, we can avoid these pitfalls of definition if our test of what is a crime gives recognition to those things which fundamentally outrage the conscience of the American people. And this became at trial the idea of shocking the conscience of mankind. Mankind, of course, has now become humanity, just as the old language of enemies of mankind has been reworked as crimes against humanity. When someone at the Imperial War Cabinet asks what crime the Kaiser has been charged with, Lloyd George replies, the crime of plunging the country into war. Sir Robert Borden smoothly offers a gloss on this by interjecting that it's a crime against humanity. And there it is, the moment when the great powers begin to think of themselves as humanity rather than a coalition of great powers. At least the victors at Vienna 100 years ago merely thought of themselves as Europe. But the idea of crimes against Europe, while far more accurate as a description of extra-textual law, might seem too openly self-serving. What then are crimes against humanity? Justice Kirby noted in his High Court 2008 decision, The Queen and Tang, that those who engage in slavery, piracy, and other special crimes are enemies of mankind. François de Menthon, one of the French prosecutors at the Nuremberg war crimes trial in 1945, he's on the left, was assigned the task of defining humanity. He invokes three distinguishable concepts. The first two are familiar enough, but the third and most radical concept of humanity saw it as a unified and an indivisible category, a moral or juridical agent. But this agent had a history of applying violence to outsiders, quartering pirates, hanging war criminals, and waging humanitarian wars. This history of violence does not appear to have unseated or even qualified humanity's self-confidence. Speaking very much in this vein, Raymond Poincaré, the French president, announced also at Versailles, humanity can place confidence in you because you are not among those who have outraged the rights of humanity. But humanity here included the Belgians, French, and British, each of whom were by this time responsible for 3 centuries of sometimes violent, certainly racially inflected empire. Though the Imperial War Cabinet meeting on November the 20th began at noon, there was a lot to get through. The main line of business was the disposition of the Kaiser. What were the representatives of humanity going to do about this outlaw? But first, there were some minor matters to take care of. Lloyd George, I quote, "There are 2 or 3 questions we're not clear about. Palestine, East Africa, questions of that kind. We have not quite settled in our minds what sort of government we will set up in Mesopotamia." It was ever thus. Here are the representatives of civilization, just prior to elaborating the idea that aggressive war would be a crime against humanity, reordering their imperial outposts themselves, as Justice Pal remarked at Tokyo, the result of 3 centuries of aggressive war. I went back recently to the National Archive documentation from this meeting. How did the Imperial War Cabinet get from its own imperial consolidations and restructurings to the enemy's crimes against humanity? After all, they each seem to be grounded on precisely the same combination of non-consensual territorial acquisition and mass violation of human rights. Was there a hint of self-consciousness? What was the hinge? Well, between the surprisingly cursory discussion of minor matters like Palestine, Syria, and Iraq, and the lengthier debate about the Kaiser, there is one short announcement. A telegram is read out from the Association of Universal Loyal Negroes of Panama. It reads, "Negroes throughout Panama send congratulations on your victory, and in return for services rendered by the Negroes throughout the world in fighting, beg that their heritage, wrested from Germany in Africa, may become the Negro national home with self-government." This is passed over in silence, and the discussion moves on to the Kaiser's terrible crime of making war on Europe and the shock this delivered to the conscience of mankind. Mankind is, of course, shocked by many different things at different times. Sometimes, something the US advisors at Versailles argued when they resisted the whole idea of crimes against humanity, claiming that there was no such thing as humanity, only nations with different moral outlooks. In Jerusalem, Adolf Eichmann seemed unshockable. His thoughtlessness, indeed, was his most remarkable quality. Arendt, again. The longer one listened to him, the more obvious it became that his inability to speak was closely connected to his inability to think. He was genuinely incapable of uttering a single sentence that wasn't a cliche. He seemed, in other words, curiously affectless. At one point, he is handed some novels to read. One of them is Lolita. After 2 days, Eichmann returned the novel, visibly indignant. "This is quite an unwholesome book," he tells the guard. This is Nabokov, of course, but this is a picture from the Eichmann trial, and you can see the attentiveness of the audience. I approach a conclusion. While Eichmann was running the final solution from an office in Berlin and then Budapest, Klaus Barbie was hunting down Jean Moulin, Barbie's on the left, the French resistance leader in Lyon in 1942. Barbie might have found Moulin in François de Menthon's house, where he occasionally spent time. De Menthon at this time had become a resistance sympathizer. Barbie tortured Jean Moulin to death, but de Menthon went on to develop the concept of crimes against humanity at Nuremberg, a category of criminality that would be later applied to Barbie himself during his trial in Lyon in 1985. The Barbie case ought to be given its full name, the Federation of Resistance Fighters v. Klaus Barbie. This was to be the trial that established a judicial record of the heroism of the French resistance. There was a small problem, though. At 8:10 in the morning of April 6, 1944, Klaus Barbie sent a telex to the Office for Jewish Affairs in Paris. It reads, "This morning, the Jewish children's home, Colonie Enfants, in Izu, was cleaned. Total 41 children, aged 3 through 13 years, were apprehended. Transport to Drancy to follow." The children were transported in manacles to Paris and then sent east to the camps. All of them were murdered. 2 of the boys were executed in Tallinn, Estonia. But the trial was a curious affair. What was it about? From the perspective of the French state, it was about French resistance to Nazi occupation. Jewish groups in Lyon, needless to say, believed that the trial would provide some reckoning for Barbie's micro-Holocaust at Izu. Barbie's defense lawyer, Jacques Vergès, later to defend Carlos the Jackal and Saddam Hussein, believed the trial was an opportunity to embarrass the French state by pointing to crimes against humanity closer to home: institutionalized torture in Algeria, fascist collaboration in wartime Vichy. And so a problem emerged. From the perspective of the prosecuting state, crimes against humanity, in its then standard definition, was a category both over and under-inclusive. Over-inclusive in the sense that it threatened to encompass French colonialism in Algeria. Under-inclusive in that it seemed to be about attacks on civilians and therefore could not encompass Barbie's murderous behavior towards the French resistance. But as someone once said, every war crimes trial is saying this of the prosecuting state: we, at least, and whatever we have done in the past or might do in the future, are not Nazis. And so crimes against humanity in the Barbie trial were defined as crimes committed against anyone in furtherance of a policy of racial discrimination and National Socialist ideology. Broad enough now to cover the resistance crimes, narrow enough to exclude Algeria, where the French, at least, were not Nazis. Though we might say the court in Barbie seemed to narrow the reach of crimes against humanity improperly, this simply reflected a long-standing tendency to equate crimes against humanity with a very particular genre of crimes against humanity: the crimes of Nazis. Indeed, from 1945 to 1997, Tokyo apart, it would have been possible to figure the history of war crimes as a history of Nazi war crimes. It's there in the Australian War Crimes Amendment legislation. So in a way, international criminal law often begins in the spirit of universalism, but ends in the practice of the particular. Crimes against humanity are acts committed anywhere, by anyone, against anyone, at any time. But not here, not now, not before 1988, not in relation to this person who is protected by her official position, not in relation to these peacekeepers immunized through this or that Security Council resolution, only if the perpetrators acted in the name of National Socialist ideology, and so on. Of course, an orthodox account of the history of international criminal law inverts this trajectory, thinking of the practice of tribunals as having begun with the particular, Victor's justice at Nuremberg, and ended in the universal, the ICC, with its broad-ranging jurisdiction. So we might say that a modern, denazified, retributive legalism begins on May the 8th, 1977, the day that Duško Tadić, center, is convicted of murder as a crime against humanity. The first non-Nazi to be tried before an international criminal court in Europe since 1946, and one of the first non-Nazis to be tried anywhere for crimes against humanity. And this is the DNA. This is an image of DNA, which refers to the discovery of Martin Bormann's remains through DNA testing a year after the Tadić trial. So the opening of the post-Nazi era ends in a way with the identification of the last leading Nazi. Let me begin to come to an end. Has modern international criminal law somehow cleansed itself of the moral obtuseness and political opportunism of these early trials that have formed most of this evening's history? The legal principles certainly seem more transparent, yet the institutions are engineered in a way that makes even facially apolitical prosecution and trial unlikely. We are objects of history, as one of the defendants in the Prague show trials said on the way to the gallows. The practice of international war crimes law, too, suggests that only those on the wrong side of history get prosecuted: Gaddafi, the Lord's Resistance Army, Karadzic, Bashir. To situate the development of international criminal law in its historical setting, as I have done this evening, then, is to argue that crimes against humanity do not exist in some supervening ethical space to be picked off by appropriately articulated legal rules. Crimes against humanity are violent acts committed by enemies of mankind in concrete circumstances. And the identity of these enemies of mankind changes depending on the exigencies of the situation. Every legal rule expressed in neutral, generally applicable language seems to have another, more particular norm hovering ghost-like around it. There is less of this around now, perhaps, but the most recent articulation of a legal rule came in 2010 with the definition of aggression. And the aggressors will be defined according to the character of the act. The existence of an arguable legal case will at least partly depend, one suspects, on the particular position of the state making the case. In particular, then, international criminal law, properly anatomized, continues to be in most instances the law applied to enemies of mankind. What should we make of this history, then, to conclude? This is a matter that requires enormous delicacy. Thousands of people work conscientiously in the field of war crimes, investigating, prosecuting, helping victims, trying to reform the system, calling for universal forms of justice, arguing against great power immunity. Many more victims of horrible atrocities view a trial as their last great hope for justice. No one can read about the moral strenuousness of the witnesses in the Eichmann trial or the personal anguish of a man like Horst Lauterpacht without stopping to acknowledge that the law of war crimes has become a site of great courage and the bearer of some of the ethical hopes of humanity. Yet, there are many things seriously awry with this system of justice. And these are not just remediable defects of the sort one might encounter in the way family law is administered in France, for example. Rather, they go to the question of what it might mean to live under the rule of law in a particular society. Let me put the problem in two ways. The identity of the violator can sometimes seem more significant, decisive even, than the identity or nature of the violation. But more than this, the identity of the violation is already too narrowly imagined, creating morally suspect distinctions between different types of violence. The question always asked of the critic at this point, though, is, well, what would you do instead? In 2002, I participated in a debate about the legality of the Iraq War in Glasgow. I offered several arguments against the war. During the question and answer period, a Glaswegian man stood up at the back and asked me rather aggressively, well, what would I do about Iraq? I replied that if not intervening in Iraq constituted doing nothing, then I would prefer to do nothing. Not creating a war crimes tribunal to specifically investigate MH17 might strike many people as the right thing to do. But the objections one might have to the Bishop initiative might easily bleed into the whole edifice of international criminal law. Certainly not doing international criminal law might help us attend to other things. How helpful is it to demonize Russia using international criminal law? Haven't we been here before? At Versailles, in Baghdad? The world is very complicated, but international criminal justice can be very simple-minded and linear. How should we respond to atrocity? The truth is, I don't really know. I'm not even sure that war crimes law isn't sometimes the right answer. Maybe in North Korea, maybe in Colombia, maybe Georgia. But law often is experienced as incongruous or technocratic or literal. Could it be that the more we memorialize through elaborate legal ritual, the less we are capable of remembering as moral event? Well, what should we do? We might do some gardening. Unusually for a law journal, each front cover of the London Review of International Law features a different photograph. The 2015 Volume 3, Issue 1 cover has a photograph by Simon Norfolk from a series, A Place of Refuge, The First Safe Place. This place is a refugee camp on the border of Chechnya and Ingushetia. Many of the people living there have been in the camp since 1999. It's a bleak place, but at the center of the photograph is an image of Malika Husanova and her family standing outside their military green tent. Surrounding the tent is a formal vegetable garden, a mini Versailles, and a small gesture of hopefulness after atrocity. The story I have told began near another more famous garden at Versailles, where the great powers in 1919 engineered one of the most transformative reforms in international legal history, when war, for the first time in history, became crime. 20 years later, Leonard Woolf, that isn't Leonard Woolf, was interrupted in his gardening. I think this is Leonard Woolf. 20 years later, Leonard Woolf was interrupted in his gardening by a call from his wife, Virginia. "Hitler is on the radio giving a speech," she shouts. Leonard calls back, "I shan't come. I'm planting iris, and they will be flowering long after he is dead." Iris reticulate is a violet-coloured iris. In the final sentence of Leonard Woolf's biography, with a very English title, "Downhill All the Way," these irises are still blooming 21 years after Hitler's suicide. 9 months after Hitler's suicide, the Nuremberg war crimes trial began. In A Train of Power, Rebecca West remembers being asked what was the most remarkable thing she had seen at Nuremberg. "Well," she said, "there was a man with one leg and a girl growing cyclamens in a greenhouse." As I have said elsewhere, the bathos in this, a sort of decentering of the trial, makes us smile. This little girl is demanding our engaged sentiments, not our pitying tears. We want her horticulture to succeed. Here she is, growing her cyclamens only a few months after Bomber Command's final assault on the civilian population of Nuremberg on the night of 16th to 17th March 1945, 6 months before the Nuremberg trial begins, when 277 Lancaster bombers pulverized the remnants of the historic centre for the second time. Nuremberg refers to the trial, of course, but also now, for me at least, the bombing and the greenhouse. West sounds as if she's a little disaffected by the justice on offer at Nuremberg. And this mirrors the mood of Hannah Arendt when she goes to Jerusalem in search of justice and discovers instead spectacle. Sometimes it's permissible to be sick of justice, sick of receiving it, sick of giving it, sick of its imperfect instantiations in an imperfect world. International criminal justice, the great institutional machine, engineered by talented and humane diplomats, kept in motion by lawyers who have sacrificed material reward for a life in pursuit of humanitarian ends, directed at putting defeated enemies and human rights violators in jail, and celebrated every week in a public lecture advertising its virtues, might now, nevertheless, be one of the less auspicious ways to do good in the world. Thank you.
Well, ladies and gentlemen, I think we're probably all needing to allow that to percolate. A very evocative, sobering and challenging presentation, and I'm delighted to be able to say that the tradition of the Kirby Lecture is that we publish the Kirby Lecture each year in the Australian Yearbook of International Law, so that we'll all be able to go back and read through and absorb in greater detail the weight of what we have heard tonight. But before we draw the evening to a close, because we have fulfilled our timing for this evening, as my Dean Stephen Bottomley alluded to, I would now like to call upon Michael Kirby, in whose name this lecture is placed.
Thank you very much, Kim, for inviting me to come forward. Thank you to the Dean for continuing this series of lectures in my name. I regard it as a very great honour, and especially because all of the lecturers have been people of great distinction, and all of the lectures have been very different, and that has been a good feature of these occasions. I'd like to say at the outset how proud I am that the Cass family are here tonight. Moss Cass and his wife and family. Deborah was born in 1960 and she died in 2013. That is far too short a life for such a spirit and such a person of brilliance, a person looking at the world, looking at the way law operates in the world, looking at the way international law operates in relation to the municipal legal systems. These are aspects that have always puzzled and interested me, and not enough lawyers think about them. Think about where we are in the development of humanity and where we are in relation to the interaction between international law and municipal law. I'm very proud that this lecture tonight has been given by Gerry Simpson, and I'm very proud that it precedes the symposium which will take place tomorrow to honour Deborah Cass, who I count as a friend, a person whom I admired and respected, and I think it's been a very unique combination, and I would pay my respects to the Cass family, thank them for being here tonight and for this interrelationship between my interests, Deborah's interests and Gerry's interests. The lecture we've just heard is a very challenging one, and it will be a pity that those who come to read it will miss the drama of the event. It is not usual to have an international law lecture which has such interesting slides which show a group of very interesting characters, some of them very wicked, and some of them not quite so wicked. A young Winston Churchill peering out at us from the Imperial War cabinet, not knowing then of what was going to unfold in the future of his life and of his contributions later in his life, and at a very perilous time for international law and for humanity. I was thinking as I watched Julie Bishop's image at the United Nations of the implications of the events of the last 2 weeks in the decision on the MH17 disaster, for the report which I took some part in preparing on behalf of the Commission of Inquiry on Human Rights in North Korea. To the question, can international human rights provide justice? I think the answer is, well, we should certainly try. And if we have any doubts about it, we should sit down for hour after hour after hour of the testimony of the people who came before the Commission of Inquiry. It's online and everyone can Google it, bring it up and just sit there and watch it and ask, in the face of this testimony, do we really do nothing? Do we really just pack our bags and say, we will not have any part of vengeance because we can't escape that as human beings? We will feel a need for a response, and that may border on vengeance. We tried in our commission to do it in a different way than all other commissions of inquiry of the United Nations before. I hesitate to say that in an academic meeting, but most of the commissions of inquiry of the United Nations have been conducted by professors of the civil law tradition. They worked in private, they deliberated entirely in secret, and they produced their report. And of course, many of the situations were situations of great controversy. We decided from the beginning that we would perform our duties in the manner of the Anglo-American legal tradition, because that's the one I knew. And so we were most attentive to the due process procedures. And the procedures we adopted included respect for North Korea. We insisted that there should be respect. We invited them to come and take part. We negotiated with the governments of South Korea and Japan to permit a representative or representatives from North Korea to come to the hearings of the tribunal, of the commission. We conducted those hearings in public. We invited the public to come. The United Nations officials said, "You can't do that. It's a huge security risk." We said, "We'll take that risk." We said we would have the international media present. "You can't do that. They'll disrupt the proceedings." Well, we'll take that risk too. And North Korea declined to come to South Korea. They declined even to appoint a representative. They declined to take a part. That was their way they've dealt with the charges and allegations against them. And the question became, should that lead to a closing down of the inquiry, because we couldn't have a contradictor? But that is not what happens in a municipal jurisdiction. You proceed, but you still insist on due process. And that is what we did. And if you have any doubts, we say to North Korea, let your citizens have a look at it. The citizens of North Korea can't have access to the internet. They can't see what people say about them. There's been criticism by North Korea, but to the criticism we say, go and have a look at it. Have a look online, and let your people have a look online, and let us come and explain what we did and why we did it and the conclusions we reached. There is now quite a large body of law on crimes against humanity. It's been developed in a stumbling sort of way, and no doubt there's more development to be done. There's also a lot of law on genocide. We had a question: was North Korea guilty of genocide? Well, there's a convention on genocide of 1948, and we took that as our standard. We didn't entirely agree with what the Convention on Genocide says, because it requires that the killing of people or a group of a people should be on the grounds of race, ethnicity, nationality or religion. That was not the case in Cambodia, another place where I'd had a United Nations connection, and it was not the case in North Korea. They didn't kill people because of religion or because of their race. They killed them, or their allegation was they'd killed them because of political lack of fidelity to the regime in North Korea. And so we had to face that question, and we said, no, genocide has not been found. We did not conclude that genocide had been found. We said that may need further investigation with access to North Korea, but we can't say it. This was the application of a norm to the facts as demonstrated. And that is my understanding of what is the appropriate way to go in due process to reach a conclusion which has a normative foundation and is based in law. And so when I looked at Julie Bishop, I remembered the emotions I had a year ago when she was president of the Security Council and was able to persuade all of them, the 15 in that beautiful room, to agree on certain steps to be taken. And I must confess that I admired the way she handled that, and I admired the fact that she secured that level of agreement. And I took that as a message of hope that maybe with North Korea you could get into that room of 15 and maybe they could take steps to bring to justice the people who are responsible for the very terrible acts that are described that appear to measure up to the criterion of crimes against humanity. And I'm still hopeful that that will one day happen. That wasn't our job. We were not a tribunal. We were not a court. We were fact finders. And we said the facts should be placed before a prosecutor and someone should answer to these facts. And the facts should formulate a charge, and the law should not be stretched, but it should be applied. And you know, 25 years ago, when I was Special Representative for the Secretary-General in Cambodia, I asked people who came along to meetings with me, when these terrible things that you've told me of in the time of the Khmer Rouge were happening, did you think that what was happening was a really very serious wrong to you and to your family? And do you know what? They looked at me as if I was mad to ask that question. They said, of course it was wrong, but there was nothing we could do about it. But now we want you to do something about it. And it doesn't need for it to be written down for a person to know that killing persons with a shovel or failing to feed a population and spending the money instead on developing 20 nuclear warheads doesn't need chapter and verse to know that that is wicked and wrong, and if there is an international law, it's contrary to international law. So here we are at a kind of international Runnymede, and it's true, as Gerry has said, that there are lots of anniversaries and one of them is Magna Carta. And you can begin somewhere. And we, as a species, have begun. And if we don't continue what we have begun, the likelihood is that we'll just wipe each other out and it won't take long to do it. Last week, the 6th of August, was the 70th anniversary of Hiroshima. And unless we can bring international law to play, we needn't worry about future generations. They'll all be dead. It'll go. It'll be left to the cockroaches. And this is why I think the puzzle on which Deborah devoted so much of her life and energy is really central, not just to a lawyer's dream of a better world under law, but to human survival. And the issues that have been presented to us tonight by Gerry are really critical for thinking out how we can make international criminal law work and to make people accountable for very great wrongs, because there are people who do very great wrongs. And to say that they're not accountable to those who have suffered and to their families is simply not acceptable. And so I think this has been a real cutting-edge evening. It is a good beginning for the symposium for Deborah Cass, and it's a wonderful contribution to the series of lectures in my name, and spot on an issue of the greatest of concern to me, and I suggest very relevant to the report of the Commission of Inquiry on North Korea, which still awaits a response from humanity.
Ladies and gentlemen, whilst I have to apologise for taking us well over our allocated time, I think the rapt silence and the continued presence of you all here this evening is testament to a very compelling evening, a memorable evening, one that has been videoed, so people may be able to watch the theatrics with the published piece. as a new step forward in scholarship and attention. But to you, Michael, as well, thank you for your contributions in that area. But in conclusion, I would like to thank our Kirby lecturer presenter tonight, Professor Gerry Simpson, for a really stimulating, powerful and memorable event tonight. And as Michael Kirby has just said, a wonderful introduction to tomorrow's symposium. And I'd like to acknowledge that tomorrow's symposium is being run both by the Centre for International and Public Law and the Centre for International Governance and Justice of RegNet in the College of Asia Pacific. There are many of you here tonight who we hope to see tomorrow, where we will begin at 10 a.m. in the Springback Room. But to conclude tonight, please join me in thanking our presenter, Professor Gerry Simpson.